The United States Drug Enforcement Administration will move to reclassify marijuana as a less dangerous drug.
DEA's proposal, which still must be reviewed by the White House Office of Management and Budget, would recognize
one reason people die from fentanyl is because they get addicted to opioids and get poisoned, right?
The move would open the door for pharmacies to distribute marijuana, as well as eliminate major tax burdens.
We actually have the infrastructure to support the rescheduling of this medicine.
DEA rescheduling marijuana. All right, let's dive into the wild world of marijuana and the DEA's potential reclassification shenanigans. So picture this. The DEA, aka the Drug Enforcement Administration, is mulling over moving marijuana from the big bad boy club of Schedule 1 to the slightly less intimidating Schedule 3 category of controlled substances. Now, what's the big deal with these schedules? Well, think of them like different VIP sections at a club. Schedule 1 is the exclusive area where drugs like heroin and LSD hang out, deemed to have a high potential for misuse and no accepted medical use. But wait, marijuana's been chilling here too, which some folks think is kinda unfair.
The United States Drug Enforcement Administration will move to reclassify marijuana as a less dangerous drug.
Enforcement Administration will move to reclassify marijuana as a less dangerous drug.
Right now, marijuana is considered a Schedule 1 drug, meaning it has a high potential for abuse.
And we deal with it, Congressman, all the time.
And it makes it harder, right? The fact that it's patchwork does probably make the job of DEA agents harder.
The proposal still needs to be reviewed by the White House and a judge before a final rule.
So the DEA's thinking of moving it down to Schedule 3, rubbing shoulders with drugs like ketamine and certain anabolic steroids. But what does this mean for Mary Jane's legal status? Well, Schedule 3 is like the VIP section with a bit more leniency. These drugs are recognized as having a lower potential for misuse compared to Schedule 1 buddies. Plus, they're considered to have accepted medical uses, which is a big deal. So if marijuana gets the green light for Schedule 3, it could mean smoother sailing for medical marijuana programs, and possibly even open the door for more research into its therapeutic potential. But hold up, we can't forget about the legal mumbo-jumbo. Rescheduling marijuana could stir up a big old pot of legal soup, especially when it comes to federal versus state laws. You see, Uncle Sam still sees marijuana as a no-no, but many states have waved their magic wands and said, "Hey, Mary Jane, you're cool with us." So if the DEA gives marijuana the Schedule 3 thumbs up, it could shake things up in the legal landscape. Federal raids on dispensaries might cool down, and states might feel more empowered to blaze their own trail with marijuana laws. Federal firearms laws. All right, let's unpack the tangled web of federal firearms laws and marijuana use. So here's the lowdown. According to the big bosses in Washington, if you're hitting the bong or popping some edibles, Uncle Sam says you can't be packing heat. Yep, that's right. Federal laws put the kibosh on anyone deemed an unlawful user of controlled substances, including our good old friend Mary Jane, from getting their hands on firearms. Now, where does this all come into play? Well, let me introduce you to Form 4473, aka the Firearm Possession Questionnaire. When you waltz into your local gun shop, the nice folks behind the counter will hand you this bad boy to fill out. And right there, smack dab in the middle of all the questions about your name and address, you'll find the golden question. Are you an unlawful user of or addicted to marijuana or any other controlled substance? Answer yes, and sorry, Charlie, but you're out of luck when it comes to legally snagging that shiny new firearm. But wait, it's not all sunshine and rainbows. See, while federal law might be waving the no guns for stoners flag, some states have thrown a curveball by giving marijuana the green light. Yep, you heard me right. In certain corners of the good old US of A, Mary Jane is as legal as your grandma's apple pie.
In an historic shift, the Justice Department will move to loosen federal restrictions on marijuana.
DEA's proposal, which still must be reviewed by the White House Office of Management and Budget, would recognize
from a Class 1 drug, along with cocaine and heroin and the like, to a Class 3.
This move would reclassify it to Schedule 3 with drugs like ketamine and anabolic steroids.
Because currently, at a federal level, that's not even possible except for one university down south.
So what happens when federal law and state law square off in the ring? Well, that's where things get sticky. While states might be cool with you lighting up a joint, federal law still says hands off when it comes to firearms. It's like a game of legal tug of war with marijuana users caught in the middle. Judicial challenges. All right, let's dive into the courtroom drama surrounding the clash between firearm possession laws and marijuana use. Strap in, folks, because it's about to get legal up in here. Recent court cases have been shaking up the status quo when it comes to whether marijuana users can pack heat. Some brave souls have taken Uncle Sam to court, arguing that denying them their Second Amendment rights just because they enjoy a little puff pass is downright unconstitutional. And you know what? They've been making some waves. One case that's been making headlines is U.S. versus Daniels, a showdown in the Fifth Circuit Court of Appeals. Here's the scoop. Mr. Daniels found himself in hot water after admitting to using cannabis while also owning a firearm. But instead of taking his punishment lying down, he decided to take his case all the way to the big leagues. And guess what? The Fifth Circuit Court sided with him, saying that Uncle Sam's laws were a bit too harsh when it came to marijuana users and their gun rights. Talk about a legal smackdown.
One reason people die from fentanyl is because they get addicted to opioids and get poisoned, right?
DEA will take public comment on the plan to move marijuana from its current classification as a Schedule.
The medical uses of marijuana and acknowledge that it has less potential for abuse than other dangerous Schedule I drugs.
The move would open the door for pharmacies to distribute marijuana, as well as eliminate major tax burdens.
But the fun doesn't stop there. Oh no, there's been a whole slew of other court rulings shaking things up in the legal world. Some courts have been throwing their weight behind marijuana users, saying that denying them their Second Amendment rights is like trying to swim upstream with a rock tied to your ankle. Others have been a bit more conservative, sticking to the old federal law trumps state law mantra. In the end, it's a bit of a legal minefield out there for marijuana users who also happen to be gun enthusiasts. While some courts are starting to see things their way, others are still clinging to the status quo. So, until the smoke clears and the gavel stop banging, it's anyone's guess how this legal showdown will shake out. But one thing's for sure, it's going to be one heck of a ride. Timeline for DEA decision. All right, let's break down the timeline for the DEA's big decision on marijuana and what it could mean for the legal landscape. Strap in, because we're about to take a ride through the bureaucratic jungle. First up, we've got the DEA's decision-making process. The bigwigs at the DEA are mulling over whether to give marijuana the green light for a Schedule III classification. But before they can make it official, they've got to jump through a few hoops.
The U.S. Drug Enforcement Administration is moving toward reclassifying marijuana as a less dangerous drug.
However, it would not legalize marijuana outright for recreational use.
Opioids is because they get prescribed opioids, and that prescription turns into an addiction.
DEA is reclassifying marijuana, and the investigation into more than 250,000 cases sidelined.
The Justice Department now wants to move it to the less severe Schedule III.
First off, they'll need to publish their proposed ruling in the Federal Register, basically the government's big old bulletin board. Once it's out there for all to see, there'll be a public comment period, where Joe Schmoes like you and me can weigh in with our 2 cents. After that, it's time for some formal hearings, where the DEA will listen to experts, stakeholders, and anyone else who wants to sound off on the issue. But wait, we're not out of the woods yet. See, even after all that, there's still the potential for legal challenges and delays. You see, once the DEA makes its decision, it's not set in stone. There's still plenty of room for folks to cry foul and take their gripes to court. And you better believe there'll be plenty of folks ready to do just that. So, even if the DEA gives marijuana the thumbs up for Schedule III, it could be a while before it actually becomes official. Talk about a bureaucratic nightmare. But what about the broader legal implications of all this? Well, that's where things get really interesting. See, rescheduling marijuana could have a ripple effect on all sorts of laws, including firearm possession. If marijuana gets the green light from the feds, it could mean smoother sailing for gun-toting Mary Jane enthusiasts. But until the smoke clears and the gavel stop banging, it's anyone's guess how this legal saga will shake out. So, buckle up, folks. It's going to be one heck of a ride. Ambiguities and definitions. All right, let's dive into the murky waters of definitions and how they impact firearm possession laws, especially when it comes to addiction and marijuana use. Get ready for a wild ride through the legal jungle.
It's very important to note this move would not legalize marijuana, but would just reclassify it.
Other drugs in that category include heroin and LSD.
Unfathomable that in 2024 it took this long to change that.
I would absolutely say the beginning of the opioid epidemic started with unlawful prescribing.
First up, let's talk addiction. When it comes to federal firearm laws, being addicted to a controlled substance is a big no-no. But what exactly does addiction mean in this context? Well, that's where things get a little fuzzy. The law doesn't exactly spell it out in black and white terms, leaving a lot of room for interpretation. Does addiction mean using a substance every day? Once a week? Once a month? Heck, nobody really knows for sure. Now, let's shift our focus to marijuana users and the criteria for determining unlawful use of controlled substances. Uncle Sam says if you're puffing the magic dragon, you can't be packing heat. But here's the kicker. What exactly constitutes unlawful use? Does smoking a joint on the weekend make you an unlawful user? What about using marijuana for medical purposes in a state where it's legal? The lines are blurry, and that's where things get tricky.
Possible reclassification of marijuana would be historic. This has not been changed for decades.
Well, essentially, Jake, it's the latest step in a multi-year process that President Biden initiated in the fall of 2022.
The proposal would recognize the medical uses of cannabis and acknowledge it has less potential for abuse.
We actually have the infrastructure to support the rescheduling of this medicine.
And speaking of tricky, let's talk about all the uncertainties and challenges in interpreting these definitions and how they affect firearm possession laws. See, when it comes to addiction and unlawful use, there's a whole lot of gray area. What might be considered addiction in one state could be perfectly acceptable in another. And don't even get me started on the challenges of enforcing these laws. With so much ambiguity, it's no wonder law enforcement officers and prosecutors have their work cut out for them. That's all for this video, folks. See you next time.